Welcome, everyone. Thank you so much for joining us this evening. My name is Adam Levine. I'm the director of the Center for Human Rights and Humanitarian Studies here at the Watson Institute for International and Public Affairs. And we are so excited to host this event with our two amazing panelists that we have this evening. After the event, we will also be having food outside, and so we will welcome all of you to stay and join us for some sushi, which is actually a little bit special, and have extended conversation with our panelists and with each other. I'm going to go ahead and introduce our panelists first, and then each of them will talk for about 20 minutes. Afterwards, we'll have about 20 minutes of Q&A with the audience, and then we'll break for dinner afterwards. Come on in. So our first panelist is actually one of our visiting scholars this year at the Center for Human Rights and Humanitarian Studies. His name is Andrew Boyle, and he's an attorney with experience in domestic and international human rights and the rule of law. He's currently Senior Counsel at States United Democracy Center, where he works on accountability for democracy violators and good governance issues. Andrew previously served as counsel in the Liberty and National Security Program of the Brennan Center for Justice, where he focused on presidential emergency powers, an issue that may be of interest to some these days, as a fellow in the Brennan Center's Democracy Program, where he worked on campaign finance reform, and a judicial law clerk for a federal appellate judge. Internationally, Andrew has worked investigating and prosecuting atrocity crimes at the Kosovo Specialist Prosecutor's Office in The Hague, at the UN Assistance to the Khmer Rouge trials in Cambodia, and he also worked in the trial chambers of the UN International Criminal Tribunal for Rwanda. Our second panelist is Yasmin Chubin, if that's correct, who co-leads the Clooney Foundation for Justice's Docket Initiative, which gathers evidence to initiate prosecutions against perpetrators of mass atrocities and represents survivors in court. As the Docket's legal advocacy director, Ms. Chubin leads investigations and litigation related to the Democratic Republic of Congo, Venezuela, and Darfur. In this capacity, she previously served as co-counsel to Amal Clooney and co-represented 126 victims in the International Criminal Court's pretrial proceedings against Sudanese militia leader Ali Kushaib. Prior to her current role, Ms. Chubin spent 10 years as a prosecution trial lawyer and an investigative lawyer at international courts, including the International Criminal Court, UN International Criminal Tribunal for Rwanda, UN International Criminal Tribunal for the former Yugoslavia, and the UN Khmer Rouge Tribunal. She was also a UN-appointed expert in prosecutions and investigations for the Special Criminal Court in the Central African Republic. So taken together, our two panelists have literally decades of experience working in international humanitarian law. I'm sure they'll share with you a bit about their pathways and careers, as well as the work that they do, and they'll be very happy to take your questions afterwards. So please hold them to the end of their presentations. Thank you again for coming this evening, and please do subscribe to our newsletter if you're not already on it. You can find that on our website, or just Google Brown CHRHS and you'll come up with it, because we have a number of other great events coming up later this semester, including a workshop on AI for good and another workshop later in the semester on reproductive justice. So please take a look at those events as well. Thank you guys so much.
Bear with me while I get this working. I think we're almost there. All right. There we go. Well, first of all, thank you so much, Adam, for that kind introduction. Thank you to Brown and to the Watson Institute for having me and for allowing us to put on this presentation. Thank you also to Maggie for all of your preparations and making sure that this came off. I know that it was a lot of work. This evening, I'm going to talk a little bit based on my experience at the Khmer Rouge Tribunal about the Khmer Rouge and about the Khmer Rouge Tribunal in particular. And then Yasmin will talk about transitional justice in sort of a broader scope and what that allows for and how the Khmer Rouge Tribunal fits into that context. And then, as mentioned, there will be time for questions and answers at the end. It's actually a very appropriate time for us to be having this discussion about the Khmer Rouge and about the Khmer Rouge Tribunal because in April, it's actually the 50th anniversary of the entrance of the Khmer Rouge into Phnom Penh, which started the period of democratic Kampuchea, under which the atrocities that we will be discussing and which the Khmer Rouge Tribunal dealt with occurred. So it seems like an appropriate time to be talking about these things. The history of Cambodia obviously is very rich and very lengthy, as anyone who knows about Angkor Wat can attest. But for our purposes, we're going to start in the 20th century. Cambodia was a French protectorate at the beginning of the 20th century. It was occupied by Japan during World War II. It then reverted back to being a French protectorate, and then gained its independence under a king in 1953. And there were communist factions that existed within Cambodia at the time that were in opposition to the king and to the prime minister at the time. There was also implications with the war in Vietnam that ultimately developed later. First, because of, as you can see in this picture up here, both the Ho Chi Minh Trail, which is the red trail coming down, passed through parts of Cambodia, and what was known, it's less known maybe in the United States, but something called the Sihanouk Trail, which was bringing weapons in from the coast towards the war in Vietnam. The United States, therefore, had an interest in the transport of goods and weapons and people along these trails, and this resulted in very extensive bombing of Cambodia, part of it illegally because the president at the time, President Nixon, did not inform Congress that the United States was bombing Cambodia. This was part of what was called Operation Menu at the time. And then also in support of the Cambodian government, there was also bombing that occurred in Cambodia. So you see here a map at the bottom of Cambodia. All of the red dots are an indication of bombs dropped. It's estimated, although it's not known for sure, that about 500,000 tons of bombs were dropped on Cambodia in a 6-year period, which is a massive amount of bombs. And there are different theories about the extent to which that extensive bombing, disruption of society, the agrarian society, drove, particularly on behalf of the government of Cambodia, drove certain elements of society towards the Khmer Rouge, which was telling everyone, and somewhat rightfully so, that this was happening because of the government of Cambodia. But the Khmer Rouge really got a much larger influx of support starting in 1970. In 1970, that is when the individual on the right, his name is Lon Nol, he was a general in the Cambodian government, overthrew the king, who is seen here on the left with Jackie Kennedy in the 1960s when she visited Cambodia. The king was out of the country at the time, and the king had been going back and forth in his loyalties or in his alliances, and had been moving away from allowing the United States to fight various forces in Cambodia or stopping the import of arms. And so while the king was out of the country, Lon Nol commits a coup. There are various theories about to what extent the United States was involved in this coup, knew about this coup. They certainly did not complain about the coup happening, because they saw Lon Nol as much more receptive to the United States than was the King Sihanouk government. And this causes the king to embrace the Khmer Rouge. And he publicly starts supporting the Khmer Rouge from outside of the country under the theory that if the Khmer Rouge win, they will place him back in power. Anecdotally, the term Khmer Rouge was not a term that the group used about themselves. It's actually a term that Sihanouk gave them. It means the Khmer, which is the ethnic group, and the Red because they are because they are communist. And so he was the one who actually coined the term the Red Khmer. So you see the king here embracing Khieu Samphan, who we will talk about a bit later, who was one of the people that was prosecuted at the Khmer Rouge Tribunal. You see him in the jungles here as well on the right-hand side. So there's a huge increase in support for the Khmer Rouge. The fighting continues. A lot of refugees start streaming into Phnom Penh for protection because the fighting is reaching them. And eventually the Khmer Rouge close in on Phnom Penh. And as they are getting very, very close, the United States government starts pulling out. These are photos of what's called Operation Eagle Pull, which was the evacuation of the U.S. Embassy from Phnom Penh as the Khmer Rouge were closing in. And the American government offers to the Khmer Rouge, to the Lon Nol government senior leadership to extract them from the country and to give them refuge, because it was clear that the Khmer Rouge had designs on them and on their physical well-being. Lon Nol accepts that. He lives out the rest of his days in the United States. He ends up dying in California in 1985. But there were other people who did not accept that offer. One of them is this individual on the left here, Prince Sirik Matak. He was part of the royal family, but he was also within the Lon Nol government. And he was, in responding to the letter, to the offer to extract him, he wrote a poignant letter back to the U.S. ambassador to Cambodia, which I'll read because it's fairly brief, but also very powerful. He says, "Dear Excellency and friend, I thank you very sincerely for your letter and for your offer to transport me towards freedom. I cannot, alas, leave in such a cowardly fashion. As for you, and in particular for your great country, I never believed for a moment that you would have this sentiment of abandoning a people which has chosen liberty. You have refused us your protection, and we can do nothing about it. You leave us, and it is my wish that you and your country will find happiness under the sky." The Khmer Rouge then enter the country, and Sirik Matak is killed within about a week of their entry into the country. So then this is photos of the Khmer Rouge actually entering into Phnom Penh. You can see that in the bottom two photos, originally there is some jubilation, both that the war is over. The war had lasted a very long time. There is a possibility or an expectation, even amongst soldiers of the other side, that maybe this would be certainly the government was going to change, but maybe it would be an opportunity for just a different government and for them to continue living their lives. And anecdotally, these photos are possible because a number of foreign journalists and photographers it's possible for us to have them because a number of foreign journalists and photographers stayed behind in Phnom Penh as the Khmer Rouge were entering. They did not take flights that were available to them out of the country. They eventually were all placed in the French embassy and then evacuated by the Khmer Rouge a couple of weeks later by truck across to the Thai border. If any of you have ever seen the movie The Killing Fields, it's based on the experience of Sidney Schanberg, who was a New York Times reporter who stayed behind in Phnom Penh, and that sort of depicts what was going on there. Anyway, the initial possibility of just a sort of peaceful change in government changes very quickly. The Khmer Rouge forces everyone out of Phnom Penh. Ostensibly, this is because they're telling people that the U.S. is going to bomb Phnom Penh, and so everyone has to get out. This is for their safety. They would be coming back in 3 days, so they don't have to bring very much. They also force out everyone. So elderly, young, hospitalized people are forced to walk very long distances along roads out into the countryside. Some of them are instructed to go to places they had moved from. There was a large refugee population in Phnom Penh at the time. This is the hottest time of the year. April is the hottest time of the year. It's right before the monsoons. And a lot of people, they're not cared for in these travels. A lot of people get sick and die during this initial move out of Phnom Penh. At the same time, people are being, whether it's on the way or when they reach these places, they are interrogated about who they were, where they came from, what they were doing under the last administration. And that also leads to targeting of individuals and victims. But this is essentially the start of the period of democratic Kampuchea. It doesn't actually get that name for another 6 months or so, but it will then last until January 7th, 1979, so almost 4 years of time. I'll briefly touch on some issues about control under the Khmer Rouge. The Khmer Rouge had formal titles in the government, but there was also the main power that they had came from their roles within the Communist Party of Kampuchea. And so Nguyen Chea, Ieng Seri, and Khieu Samphan, three of the individuals that I'll talk about that were put on trial, they all had senior roles here in the Communist Party of Kampuchea, with their roles within democratic Kampuchea government being less important in that regard. And so they were making the decisions. You can see here that this is a document of standing committee meeting minutes. So you had the Central Committee of the Communist Party, and then within that, the Standing Committee, which is the most powerful body. And you can see here the attendance of the Standing Committee meetings. You have Pol Pot, who is well known, but he was not put on trial because he passed away before the trials got up and running. Nguyen Chea, Khieu Samphan, also they were put on trial later on, and I'll mention them later. They were also the recipients at this central apex in Phnom Penh of information from the field. So here's a telegram coming in from the field from another Khmer Rouge recipients. And you have Pol Pot, Nguyen Chea, Ieng Seri, and Vorn Vet, and a copy sent to Khieu Samphan. Again, Nguyen Chea, Ieng Seri, Khieu Samphan will be put on trial. Pol Pot dies. Vorn Vet, he was a member of the Standing Committee. However, he was a victim of internal purges that happened within the Khmer Rouge. At various points, the Khmer Rouge, which was very, very paranoid, believed that portions of the Khmer Rouge had actually turned against them and therefore had to be liquidated. And that was also something that occurred under the Khmer Rouge. Below the standing and central committee levels, the country was divided up into zones. So you have the Northwest, Northeast, North, Central, West, Southwest. These shifted a bit over the period of democratic Kampuchea, but you had heads of these zones, and then beneath that you had district and sectors. And those were also the people that we were looking at as part of the Khmer Rouge Tribunal. And so the Khmer Rouge instantiates these policies from the top down and reported on from the bottom up. Amongst those, forced transfers of people. We talked about the forced transfer at the beginning. There were other forced transfers. There was ideas of moving people to areas of the country where that were best to grow rice. And so you would have these forced labor camps. You had to have the people there. And so you would forcibly transfer people there. Collectivization and forced labor. The Khmer Rouge had this idea that they were going to make a great leap of their own, almost like China did or tried to do by rapidly industrializing through the cultivation of rice. They were going to grow an immense amount of rice, a scientifically impossible amount of rice. They were going to export this rice, and they were going to, and therefore build up the capital to rapidly develop beyond everyone's wildest dreams. They abolished religion. They had a principle of forced marriage. They saw marriage and family as in opposition to the party and to the revolution. And so they wanted to be in control of binds outside of the party. And so while they needed people to have families because they were purging a lot of people, they were killing a lot of people, and they needed people to work. They also wanted to control that. So they would make decisions about who was marrying whom. And that was also something that was looked at by the tribunal. They purged a lot of enemies, and those enemies included people of Vietnamese descent, Cham, which is a Muslim minority, former soldiers and government folks from the former Lon Nol government. And they established a whole bunch of security centers, prisons, essentially, where they would torture and kill people throughout the country. So these are just some photos really quickly of what I was just talking about. You have a forced labor site, a forced marriage, and then a mass grave from the killings that occurred. There's also reports that came in about their killing and targeting of Vietnamese. Yuan is a derogatory term for Vietnamese that the Khmer Rouge used. So this is a report claiming that they were CIA agents. You had them also saying that they were KGB agents. Smashed is a euphemism for killing, as was swept away. And they're reporting on the killing of young and old Vietnamese persons within the country. Here's a map of the various security centers around the country. As you can see, they all sort of lead to, or maybe you can see right here, S21 right at the center. That's in Phnom Penh. It's considered the most important. That's where the important prisoners were all transferred to. And this is a picture of S21. It was an old school. It's a modern picture, so you wouldn't have had all of these modern buildings around it, but the school was converted into a prison with the buildings around having the prisoners. And in Building E, that's where the photographs and biographies of entering prisoners were taken. We have a lot of photographs of prisoners. You can see both women and children were brought into this prison. And incidentally, we have a lot of these documents because when the Vietnamese pushed the Khmer Rouge out of power, it happened so fast that they didn't have time to destroy them. Another aspect of the prison center was forcing confessions. Here we have a cover page of one of the confessions and the note on the top from Nguyen Chea to Ieng Sary. A lot of pseudonyms were used in this process, and they would get people to confess to various crimes against the revolution and then kill them. Here's our first note of Kanguk A, alias Doik, who was the head of the S21 Center. He was also going to be put on trial by the Khmer Rouge Tribunal and convicted. I'll go a bit quicker because I know I'm running over, but here's some reports from the S21 Tribunal, S21 Prison Center, reports of individuals that of the killing of individuals and decisions made. You can see that Doik proposed to Ankar. Ankar agreed. Ankar was a term for the organization, and that generally meant any leadership position and ultimately the standing committee. And this also, you had similar reports. Didn't mean to do that.
Back.
Yes, back is not there. Similar reports at other prison centers. So the Cambodian tribunal is set up in the Khmer Rouge is pushed out of power in 1979, but the court doesn't become operational till 2007. That's a big lag in time. Part of that is internal dynamics in Cambodia. There continues to be a civil war between the Khmer Rouge and the government that's set up by Vietnamese with Vietnam, which invades because Cambodia is attacking across the boundary with Vietnam, and they're annoyed by that. But also the whole institution, which Yaz is going to talk about, of international criminal justice doesn't really get off the ground again until the 1990s, post-Cold War. You have the ICTR, the ICTY, and then ultimately there's a lengthy 6-year negotiation between the UN and the government of Cambodia to set up this tribunal. Originally, they wanted it to be completely international. It ends up being what's called a hybrid tribunal, and I know Yaz will talk a bit more about that. It's based off of the Cambodian legal system, so it has a lengthy judicial investigation period that precedes the trial, that is somewhat foreign to common law legal systems. So it finally completes 3 trials. One is against the head of the S21 Security Center. This is him, Kangageo. He had escaped. He's the guy that everyone was in the Khmer Rouge was mad at because he didn't destroy the records when the Vietnamese came in. He's discovered on the border. He's ultimately convicted of crimes against humanity and war crimes. He admits to a lot of it, but at the very end of his trial says, "No, you should set me free." He's convicted, sentenced to life in prison, and he has now passed away, but he lives out the rest of his days. And then the second and third trials are against the same group of people, just broken up to be into 2 separate trials because there were so many charges and there was worries about how long it would take. So it's against Nguyen Chea and Khieu Samphan, who you've heard me speak about already. That's Nguyen Chea on the left, who's brother number 2. He is the second in command after Pol Pot. There's Khieu Samphan, who is a member of a de facto member of the standing committee, and the head of the state presidium. And then Ieng Seri and Ieng Tirit, they are husband and wife, Minister of Foreign Affairs, Minister of Social Works. But they actually drop out at some point because Ieng Seri passes away, and Ieng Tirit develops dementia, and so can no longer participate in her defense, and so therefore cannot be tried. The only one who is still alive out of all of these is Khieu Samphan. He's in his 90s. They are convicted, him and Nguyen Chea are ultimately convicted of war crimes, crimes against humanity, and genocide against the Cham and the Vietnamese, and are sentenced to life in prison. And this is just a couple of pictures of people testifying. We had experts, including Professor Hinton, who is a genocide expert. This is a Cham victim testifying, and that's just a picture of the courtroom. And then finally, I'll mention that there were cases against these individuals. These were lower level, head of the Navy, Mas Mut, and some sector and district level people that the cases did not go forward. This comes from, we can talk about in the Q&A, but this comes from the hybrid nature of the court. There was an international side, a national side. They did not agree on whether these cases fit within the court. The international side said they should go forward. The national side said they should not. And therefore, these cases were not prosecuted. And I would put that at one of the failures of the court, but we can talk about it later. And then finally, and there's the legacy of the court. This is two of the victims of the Khmer Rouge. One of them was one of the handful of survivors, the one with his back to us, from S21, and the other lost Chome. He lost 4 members of his family, and that's right after the verdict was read in the second trial. But there's also a lot of reparations that came out of this. There are people that are critical, victims that are critical, that it took too long and it was too expensive. There are also collective reparations, healthcare that was provided, monuments, public education programs, and the like. So I will stop there and turn it over to you guys.
Good afternoon. So I'm Yasmin Chubin, and thank you to Brown and the Watson Institute for having me, and Andrew for suggesting that I come along. The last time I was here, I was visiting in 1999. I was a college student myself, but I'm aging myself and digressing. So I should just add that my presentation is given in my personal capacity, and I'm not representing the views of the Clooney Foundation. So Andrew gave you a brief history of the atrocities in Cambodia and the work of the Khmer Rouge Tribunal, which I'll mostly refer to as the ECCC. I'll try to give you an overview of the landscape of transitional justice mechanisms, how they developed over time, and where the ECCC fits within that landscape. And if there's time, some current trends. So the development of international criminal justice was a reaction to the massacres of the 20th century. As I'm sure you know, the first international tribunals were set up during the post-World War II period with the Nuremberg trials and the Tokyo trials. And those were the first real international criminal tribunals, setting precedents for prosecuting war crimes, crimes against humanity. Later on, these were seen as administering victors' justice, and neither of them established a permanent international court. And I should also mention that when we speak of international crimes, it's a bit of a confusing term, because the crimes aren't referred to as international because of their intrinsic international character, but rather because they violate values considered universal, affecting human dignity as a whole. So the idea of international criminal tribunals really began to gain momentum in the 1990s. In the early 90s, following reports of widespread atrocities in the former Yugoslavia and then Rwanda, the UN Security Council established tribunals to prosecute these responsible for the crimes. So these were fully international courts. So international judges, prosecutors, the defense lawyers, and the court administration were all international. These were set up under Chapter 7 authority of the UN Security Council in 93 and 94, and each started being active about a year later. And the hope was that they would stop the atrocities. They were still ongoing in former Yugoslavia at the time of the setup, and stop them from reoccurring in Rwanda or continuing in the neighboring countries. So a little bit about the ICTY. It was based in The Hague. I was a prosecution intern there in 2002, and it led to my decision to go to law school. So it was set up in 1993 and operated for 24 years, prosecuted genocide, war crimes, crimes against humanity, tried 111 individuals, including Slobodan Milosevic. And so this was the first trial of a sitting head of state by an international court, which was quite momentous. One of the tribunal's most significant achievements was the conviction of Radovan Karadzic and Ratko Mladic for the genocide at Srebrenica, where over 8,000 Bosnian men and boys were killed by the Bosnian Serb forces. And this was important because it determined that the massacre was not just a war crime, but constituted genocide, even though it was only impacted a portion of the population. So at the ICTY, one of the most shocking moments was during the trial of Milosevic, where he would treat the trial as a circus in the courtroom, as his personal sort of audience, his stage. And he laughed and mocked the judges, laughed out loud, disrespected the court, was always trying to put NATO on trial, and really refused to recognize the court's legitimacy. And people often wondered if, well, as they're wondering again now, because we go through ebbs and flows, but whether international justice can truly hold powerful leaders accountable. And then Milosevic died during his trial before there was a judgment. And some claimed it was a natural death. Some claimed he was poisoned. It was never fully clear, but it did send a message that even heads of states can be tried. And it paved the way for trials of other heads of state. So Charles Taylor, later by the Special Court for Sierra Leone, and then Omar al-Bashir, Sudanese leader, and Vladimir Putin, who've both been indicted by the ICC, even though they haven't been arrested yet. And then the Crime Tribunal for Rwanda, the second ad hoc tribunal. So that's where Andrew and I met when we lived in Arusha, Tanzania. So it was set up in Tanzania, not in Rwanda, for security reasons. Rwanda's justice system had been decimated, but mainly for witnesses to be able to travel to the seat of the court and testify, particularly defense witnesses who were no longer necessarily living in Rwanda, for them to feel safe enough to come testify. That was not seen as possible in Rwanda at the time. And so the tribunal was split, with a small office in Kigali, the capital of Rwanda, and the main court in Arusha, Tanzania. So the Rwanda office was there for prosecution investigations. A lot of the investigators were based there, but also to facilitate witness travel to Arusha to testify. In its heyday, the court had a small plane that would go back and forth between Kigali and Arusha. And staff were also allowed to take the plane to go visit Kigali on the weekend when there was availability. So some of the highlights of the ICTR, it was the first institution to recognize rape as a means of perpetrating genocide, and that was a huge landmark decision. It was also the first to hold members of the media responsible for broadcasts intended to inflame the public to commit acts of genocide. So incitement to commit genocide. I'll tell you about a case of the bulldozer priest who turned his church into a mass grave. his name was Father Atanaz Saromba. He was tried at the ICTR and given a life sentence. And when the ethnic Hutu militias couldn't break into the church where a lot of Tutsi refugees had gone to hide, he ordered a bulldozer to knock it down, basically killing everyone inside. And some of the testimony, survivors heard him say, the problem will be solved once the church is gone. He later fled to Italy and continued working as a priest under a false identity. And then in 2002, he was arrested and brought to the ICTR and sentenced to life in prison for genocide and crimes against humanity. And it was historic because it showed that even religious leaders who participate in mass atrocities could not escape justice. This is a quote from Benjamin Ferencz. There can be no peace without justice, no justice without law, and no meaningful law without a court to decide what is just and lawful under any given circumstance. Now, he was the chief prosecutor of the Nuremberg tribunals and a lifelong advocate for the establishment of a permanent tribunal. So his advocacy was seen as instrumental in the creation of the ICC. The next international criminal court that I'm going to speak about. And this is the permanent court. It was established by statute, the Rome Statute in 98, entered into force in 2002. Has 125 member states, but quite significantly, many of the global powers, China, India, Russia, the US, are not members. And it can exercise jurisdiction in specific instances. So the crimes have to be committed by a state party's national or on the territory of a state party, so one of the 125 member states, or the UN Security Council has to have referred the case to the ICC, and that's happened on the Libya situation and the Darfur Sudan situation, and only those two, or a state has to consent and give temporary jurisdiction to the ICC. That happened initially with Ivory Coast, for example. It's intended to complement national jurisdiction, so a court of last resort, only taking cases when the national system is unwilling or unable. So if the justice system has been destroyed or they can't guarantee a fair trial or security. It targets individuals, so not states and not corporations. And it's held 32 trials so far. Notably, all the trials have focused on African situations. There are a number of investigations and situations open in other countries. So Ukraine, Palestine, Venezuela, just to name a few. But the trials that have occurred so far have all been focused on Africa. A few of the key cases so far, the Lubanga case, it's a Democratic Republic of Congo case. He was found guilty of recruiting and using child soldiers. Ntaganda, he was found guilty, a first conviction for sexual slavery. The Al-Mahdi case, he was convicted of destruction of cultural heritage. And the Ongwen case, he was convicted despite him being a child soldier himself. So that raised a lot of questions about whether that's an excuse or a justification as a defense. Many challenges with the ICC. So unlike the Khmer Rouge Tribunal or the former Tribunal for former Yugoslavia or Rwanda, the ICC has to deal with all of these different situations. And with the more focused tribunals, the staff would become experts eventually in the history, the culture, the language. They were also placed generally closer to the countries that they were working on. And so the ICC has these challenges of distance, cultural awareness and language, the cost, and it really relies on cooperation as opposed to UN Chapter 7 authority. So the three courts I've talked about so far are all purely international. And I'm going to move on now to the hybrid courts, like the Khmer Rouge Tribunal, or the ECCC that Andy spoke about. But there are a number. There have been 5 so far. So the Special Court for Sierra Leone is another, and the Special Criminal Court in Central African Republic. Those 3 have all been in-country. And then there's the Special Tribunal for Lebanon and the Kosovo Specialist Chamber, and those are in The Hague. The strengths of these is that they have local engagement. There's generally a mix of international staff and national staff. So they're far less expensive than the international courts, and they lead to capacity building and more legal expertise for the country that they're placed in, or that they're working on once their work is over. The challenge is, as Andrew touched upon, there's political influence in the hybrid model when you're dealing with international and national, depending on the position of the national government at the time of the establishment of the court or when the trials are happening. For example, on cases 3 and 4 in the Cambodia court, that's why they didn't go forward. It was essentially political influence. There's often financial issues. They rely on voluntary contributions. When we were at the Cambodia court, the Cambodian government would multiple times stop paying their bills, and it would lead to these terrible situations where the international staff was getting paid and the Cambodian staff for weeks or months at a time when we're coming to work but hadn't been paid. And the salaries there was already discrepancies between the salaries. And so you can imagine what kind of situation you have then. And the UN a few times advanced the money. I don't think Cambodia ever reimbursed it. And then logistical difficulties when the ICTR, the Cambodia court, they were first established, you had to build or redevelop a courthouse. And for example, in Arusha, that meant you had to make some roads or pave them that led to the court, and bring internet and ensure generators for power. So in Central African Republic, the same. Depending on the setting, it can be quite challenging. And so I'll now move on to the exercise of the international criminal law within the national courts. So we've had the international courts, the hybrid courts, but we now have more and more national courts applying this type of law, and they do it. Some countries have domesticized the Rome Statute, the statute that led to the ICC, and others haven't done that as formally and exercise what's called universal jurisdictions. So as everyone's aware, nations typically exercise jurisdiction over crimes committed in their own borders or involving their own citizen. Universal jurisdiction deviates from this norm by empowering national courts to prosecute specific grave offenses, irrespective of where they occurred or the nationalities of those involved. The idea is that these crimes are so egregious that it is the duty of the international community as a whole to prosecute these types of crimes. And we're seeing in recent years, there's a real increase in universal jurisdiction cases. For now, it's often in the same country. So Germany, France, Argentina, Sweden to some extent have been from leaders, but we've many countries actually have laws on the books or laws that are permissive enough to allow these cases, and I think we've realized sort of as practitioners or as the community that is interested in these crimes not going unpunished that you really need both. You can't rely on just an ICC or just a few international tribunals. You need both to coexist and work in parallel. So, and this is some of the work that I'm currently engaged in and that we're doing at the Clooney Foundation. I think we're running out of time, so I'll go quite quickly. But there's the Roger Lumbala case. The crimes were committed in DRC during the Second Congo War. He was living in Paris under a different name and was arrested in 2020. We're representing a number of victims in that case. He's charged with crimes against humanity, including slavery, torture, summary executions, and very exciting. The case is actually going to trial at the end of this year in November, December in Paris. And it's exciting because in this line of work, the pretrial and investigations take years and years and years. And so to actually get to trial is sometimes people work on the investigations and the pretrial for 5 years and move on with their careers and never get to actually see the trial. And so it will be, because it's the French system, we know exactly how long the trial will be. It'll be 5 weeks at the end of the year. And then in Venezuela, there was repression of anti-government protests in 2014, and security forces are alleged to have committed crimes against humanity in their response to the uprising. The ICC is investigating, but it hasn't moved very quickly. And so a team of lawyers from the docket, the CFJ's The Docket, has been investigating as well. And we have applied to open a case in Argentina under universal jurisdiction. And the Argentine federal court has now opened a formal investigation, and we're representing a number of victims in that case. That's still in the pretrial sort of investigative phase with an investigative judge. Again, the civil law system, but it's open, and we saw the Argentine courts recently indict in the UJ and the Myanmar situation case. So we're quite hopeful that there's a positive trend. I'll quickly go back to the ECCC. So it was a hybrid court applying both Cambodian and international law with a co-investigative structure and victim participation. The challenges, political interference, funding, disagreement between the judge, the passage of time and how old the accused are, and only limited trials. A huge accomplishment was that so many Cambodians attended these trials, and we don't see that in The Hague or in Arusha because the citizens don't live there, and so they can't attend quite so easily. And that was, I think, one of the most positive aspects of the ECCC and quite unique. So in conclusion, we're seeing that transitional justice is evolving. There's no one size fits all. The ECCC was an experiment with mixed results, and in future mechanisms, we'll have to balance international expertise with local legitimacy. I'll stop there, or we won't have any time for questions.
So thank you both again for joining. I'll just start us off with the first and only question that I'll ask, and then we'll open it up. So please, all of you, prepare your question, and we have a mic that we will bring around for you to ask it. But you both talked very eloquently about your work, but I was wondering if you could tell in just a couple of minutes what got you into this field and what pushed you into this field and how you made your path forward to get to where you are.
You go first? Okay. Well, I guess my first exposure to this field was actually as doing an internship when I was in law school. I had an opportunity to, when you're in law school, you have 2 summers between your 3 years of law school to go out and have practical experience. And I ended up doing an internship at the Rwandan Tribunal. And Up until that time, I had been focused mostly on domestic civil liberties issues, and the idea that I could get involved in international human rights. I was very excited about the prospect of working with the UN. Then having that experience and sort of seeing people around me that had made their career in this field. And at that time, dating myself, but this is the early 2000s. And it really seemed like a field that kept growing and growing and growing. And I think, there's been a lot of changes. Like, for example, universal jurisdiction is something that is definitely growing. There have been developments about it in other ways. But it's also a field that, for example, the American president has now sanctioned the head prosecutor of the ICC. So it's a field that is changing a lot. But at the time, it just felt like there was going to be a lot of growth in that area, and it was just tremendously fascinating. And I found interesting both the legal aspect of it, because it's a new field of law with a lot of big questions that new questions you can dig your teeth into, and also the opportunity that Yasmin was talking about, that you, alongside the actual legal work, you get to learn the history of the place. You get to meet the people. Sometimes you get to learn the political aspects of what occurred, and I found that really, really fascinating.
Please just use the mic.
Yes, of course. I'd taken a couple classes in undergrad focused on South Africa, sort of history of apartheid, but also post-apartheid. And I think that was really what got me interested in the conflicts that you study when you're working at these tribunals. And I remember wanting to, and I heard about the ICC, and I said, I'd like to do an internship there. And it was when there were a lot of jobs, and it was right after undergrad, and a friend was like, I have a friend who worked there and put me in touch, but it turned out to be the ICTY. So I ended up interning at the ICTY and not the ICC, which showed you how much I knew at the time. And really just doing witness summaries, but it's exactly what I understood. I mean, the blend of history and, working on some of the darkest periods of human history, essentially, while at the same time, these innovative legal questions in these new tribunals. I also really liked the international staff that I met working, and then we tended to all sort of follow each other around from one tribunal to another. And so you get to know everyone quite well and work on these really interesting issues. And I was hooked.
Wonderful. All right, let's open it up to questions from the audience. What do we have? Okay, right here in the front.
As a sensible human
being. Can you just take the mic?
Okay. As a sensible human beings, I have to acknowledge your guys' effort and ideology. Okay. Now, I'm a physician, so you start to ring. Okay. And physician, I always care about the outcome analysis of human effort. So what's the global impact on the politics with all those activities?
I'm happy to give it a shot. That's a big question, but I'm happy to give it a shot. Talking about transitional justice and what is the impact. I think that the answer for that is as varied as the people involved. So, for example, even in Cambodia, there were people that talked about how important it was for them to have the atrocities that occurred to them acknowledged and to have a verdict. To those that had the opportunity to testify in court, they talked about how important it was for them to tell what happened to them and for the accused to have to sit there and listen to what had happened to them. There are others that think that the impact was minimal, it took too long, all of those sorts of things. On a global scale, I think transitional justice as a whole, putting aside the benefits to the communities, you hope that it leads to more peace in the community because there's been a process through which past harms have been acknowledged and that justice has been meted out. The hope is that to some extent it causes those who might engage in such actions in the future to think twice. I think there's certainly a mixed record about whether that's the case. Certainly atrocities have continued to occur, although I will say that in, for example, the Russian invasion of Ukraine, there was instantly almost a discussion about who was going to get sent to The Hague, even for people that didn't exactly know like what they were talking about in The Hague, but they had this understanding that there was a justice mechanism, and it is a process through which participating in these justice mechanisms, it allows countries that value the values that are being supported to say, this is what we stand for, even if some of those countries don't always live up to them, to say, we believe in that, and that is an important process. And that has normative benefits that the body from Nuremberg to today, the body of international law that has been developed through these courts that say, this is what you can do and this is what's a crime, is tremendous.
Yeah, I don't have a lot to add, but I mean, I agree there's a fact-finding mission, a historical record. The cathartic, I think, impact on the individual victims and survivors is undeniable. I mean, I personally had a witness I was leading in court. We were discussing whether it's worth it to him to put himself through sort of this somewhat of a re-traumatization, going back through all the worst period of his life and describing it in great detail and then being cross-examined on it. And he had lost his brother during the Rwandan genocide and said he felt like he couldn't move on with his life until he testified before a judge. So I think there's that. But the bigger question in terms of deterrence, it's hard to say. I mean, I think there's ebbs and flows in terms of, as an international community, how much we value certain, what our shared values are. But what we do see is it is important enough for sort of the U.S. president to sanction the head of the ICC. It's happened twice now. And we're also seeing quite strong reactions when there's invocation of the word of genocide. No one wants to be found guilty of genocide, even if they don't believe in certain institutions. So I think that's as much as we can say.
Other questions? Back here.
Can the ICC try people in absentia? Because Putin does not accept the jurisdiction of the ICC. Is there any possibility, or for that matter, Donald Trump, is there any possibility of having a trial of somebody in absentia?
So the ICC doesn't allow for trials by absentia, although it's being explored at the moment for Joseph Kony in pretrial for the confirmation hearing stage. The special tribunal for Lebanon, though, held trials in absentia. So there could be some creative prosecution arguments in the future that based for the preservation of evidence and based on the fact that passage of time, there would be some sort of mini trial to preserve the evidence. There could be a finding, perhaps, but I think if the person were ever arrested, you'd have to reopen the trial so that they could, answer to the charges and the evidence that's been presented and present their own defense. He wouldn't be able to just sentence someone following that.
I'll just follow up to say there are fair trial rights that are implicated, obviously, by having a trial in absentia. There's also been discussion of, in the Russian-Ukraine conflict, of setting up a separate tribunal for the aggression of Russia versus Ukraine. This is a sort of a more tangential legal point, but for reasons I won't go into, the ICC cannot deal with the crime of aggression. So there's an effort underway to establish a separate court to deal with that. And then some people are discussing the possibility of dealing with proceedings in absentia there. But I mean, as you can understand, it's more complicated and in that regard. And so, for example, at the Special Tribunal for Lebanon that dealt with the bombing that killed Rafiq Hariri in Lebanon, the backstop to the fact that they did these trials in absentia was that if they ever actually got any of these individuals in custody, those individuals had the right to say, I want my trial done all over again. And so you have to sort of weigh the sort of effort and time and money against that type of process.
I'll just add that the ICC so far has never successfully prosecuted in a situation or in a country where whoever's in power hasn't allowed them to come investigate. So
I guess I was following up on your comment that once the war got going in Ukraine, it was when it's people brought to the Hague, and I don't see how that would happen.
Well, it could happen if he traveled to one of the other member states. They have a duty under the Rome Statute to arrest him and transfer him to The Hague. So, if he wants to go to a global meeting in Germany or in the Netherlands or in France, although France has recently, well, it's unclear which country would do it, but they are under an obligation to do it.
His vacation options have been really limited the last few years. Any other comments, questions? All right, we'll take this as our last one.
All right, I'll try to be brief. You talked about Nuremberg. This is regarding a political issue. And in Nuremberg, for example, obviously the Germans got prosecuted. One of the issues was with the Katyn massacre, where the Russians tried to blame it on the Germans. The Russians did not get prosecuted, despite collaborating with the Germans for about 18 months in Poland. In regards to Cambodia, obviously the Khmer Rouge, 2 million people got killed. No discussion of the Pavan killing about 500,000 Cambodians in their invasion, bombing Cambodian refugee camps in Thailand. I remember talking to a web developer who was desperately trying to make as much money as he could to get his family out of Thailand before they got killed. And I don't hear anything about that. So I'm wondering if there's obviously good work is being done, and this needs to be done. And there's a lot on your plate, but I worry that sometimes it's political. Like, for example, you're bringing up Trump. Now you're going to use that as a weapon against a political figure just because you don't like him. And it's not the genocide. There's a pursuit of genocides that are popular to pursue. The Holodomor is recent. I remember when people were laughing at Robert Conquest's book on the Holodomor. Now all of a sudden it's chic with Applebaum's book. Now they're going after them because the Russians are weak, and now it's a political thing. So how much of this is actually pursuing real international law that's been violated, mass murder, genocide, like of the Hmong, the rest of that, and how much of it is political? And is it, if I can put this in, isn't it a bit frustrating? Because it is on my end. I'm sorry.
I'll give it a shot. It is frustrating, I think, for those of us that work in the field, because there's unfortunately, far more atrocities being committed than there are tribunals to deal with them. One of the drawbacks of the international justice system as opposed to a domestic justice system is that you don't have an international police force. And so there is an inherent political aspect to what it is possible to do in the international justice place that is not as apparent in domestic legal systems. It is very much the art of the possible. And so I think that who can you arrest? Which tribunals can you get up off the ground? Which for the ICTR and the ICTY, which tribunals will the Security Council not veto? All of that has a political element. The ICC does not have a police force, so they're reliant on other countries to arrest people. All of that has a political element, and I think where many people that work in the field come down is some justice is better than no justice. And is it frustrating that you can't get everyone? Yes. Is it the best system we have right now? Also, yes. And so I think all of us would happily work on a system that was more inclusive, but we just have to be somewhat realist about it.
I fully agree. And I'll just add that with the development of universal jurisdiction, you can sort of start to close, the vacation options, as we're saying, because if Sweden, France, Argentina, Germany are all willing to try the perpetrators in their domestic system using international law, then that starts to lead to limit options and lead to perhaps a better distribution of justice.
On that note, we'll wrap up. Let's thank our panelists again.